A pig stood in a courtroom, on trial for murder. The judge was real, the charges were real. This happened over 200 times across medieval Europe. Animals were arrested, jailed, and executed by law. Not metaphor, not folktale, actual court records survive. So why did medieval people put animals on trial? The answer reveals how medieval law saw the world. The most documented case happened in 1386 in Falaise, France. A sow attacked a child, killing him. The local court arrested the pig formally. She was given a court-appointed lawyer. The trial lasted several days, with witnesses. The pig was found guilty of murder. She was dressed in human clothes for the execution. The city paid the executioner the same fee as for a man. This detail matters. Equal fee meant equal legal status. Animals were considered moral beings under medieval theology. God created them, God's law governed them. If a creature caused harm, it violated divine order. The court's job was to restore that order. Pigs were the most prosecuted animal in the records. They roamed medieval towns freely, feeding on scraps. Children were especially vulnerable, often alone with them. Records show at least 12 known pig trials in France alone. But pigs weren't the strangest defendants. In Basel, 1474, a rooster was tried for sorcery. The charge? Laying an egg, which only hens do. Medieval belief held that rooster eggs hatched basilisks. The rooster and the egg were both burned publicly. The lawyer argued the egg was laid involuntarily. The court rejected the defense. Intent didn't matter. Not all animal trials ended in execution, though. In 1750, in Vendré, France, a donkey was acquitted. The local priest wrote a character reference for him. Neighbors testified the animal was virtuous and well-behaved. The court accepted it and released the donkey. There were also mass insect trials, stranger still. In 1545, weevils were destroying vineyards in Saint-Julien. Villagers filed a formal lawsuit against the insects. The weevils were summoned to appear before the court. A lawyer was appointed to defend them. He argued the weevils had a right to eat, given by God. The court actually considered this a valid point. Villagers offered the weevils alternative land to feed on. The case dragged on for 40 years across 2 trials. The second verdict page is missing, eaten by insects. That detail survived in the court archive. Church courts handled a different category of cases. Ecclesiastical tribunals prosecuted animals collectively. In the 1500s, rats were excommunicated across France. The Bishop of Autun sent formal letters to the rats. Letters were read aloud in fields where rats lived. Barthélemy Chassenet defended the rats in court, 1521. He argued the summons hadn't reached all of them. The roads were dangerous. Cats might intercept them. The judge accepted this and postponed the trial. Chassenet became the most famous lawyer in France. His career launched entirely from defending rats. The legal logic behind all this was consistent. Medieval Europe ran on Roman law mixed with theology. Roman law said any being capable of harm could be liable. Theology said God made all creatures answerable to order. These two ideas combined into medieval animal law. Not everyone in the Middle Ages accepted this, though. Some jurists questioned whether animals had intent. Without intent, could there be true guilt? Courts argued around this for centuries without agreement. The trials also served a social function beyond punishment. Public trials gave communities a ritual for processing grief. When a child died, someone had to answer for it. A trial gave the event structure, meaning, resolution. Historian Edward Payson Evans documented 191 animal trials. His 1906 book listed cases from the 9th to 19th centuries. The earliest recorded case? A pig in 900 AD near Paris. The last documented execution? A dog in Delimont, 1906. 1906 is the same year Evans published his research. The dog was convicted as an accomplice to murder. Its owners committed a robbery. The dog assisted. The court sentenced all 3 equally. By then, educated Europe found the trial absurd, but the local court followed a tradition still alive there. These trials disappeared as legal philosophy changed. The Enlightenment separated moral agency from physical harm. An animal couldn't choose, so it couldn't sin. If it couldn't sin, a trial was philosophically nonsense. This shift took 2 centuries to fully complete in law, yet the impulse behind animal trials never fully vanished. Today, in some jurisdictions, dangerous animals face euthanasia orders. Courts still decide whether animals live or die for their actions. The vocabulary changed, the structure remained. In 1386, Falaise, they dressed the pig in human clothes. They believed the punishment had to match the crime's weight. The execution took place in the public square, officially. The city's accounts still show the payment record, a real line in a real ledger for executing a real pig. History is sometimes weirder than any story you'd invent, and that's exactly why these records matter. They show how a civilization reasoned about justice. Not cruelty, not stupidity, a coherent internal logic. A logic that took the moral order of the universe seriously, even when the defendant had 4 legs and a snout. The medieval world wasn't irrational, it was differently rational. And understanding that gap is how history actually teaches us. Not as a joke about pigs in wigs, as a mirror showing how much our own assumptions will look one day.